The European Commission's digital single market strategy could be the greatest legal hurdle facing U.S. firms operating on this side of the Atlantic. Here to share insight on what's ahead, James Mullock, a privacy and data protection legal specialist. So these new rules, unwavering in terms of how Europeans' data should be held, right? I mean, just look at the European Court of Justice's decree in the Safe Harbor Agreement case. How are your American clients reacting to this get tough approach by the EU?
Well, I think it's been quite a shock. And I think the main message that we're trying to put out is actually don't panic. There is some time to react to the removal of what has been a sort of fundamental part of Europe to US trade over the last few years, but there's not a lot of time. So we've been told by regulators that they're going to hold off enforcement action until January 2016. And that's really to see how trade discussions go between the US and the EU, to see if the politicians can come up with a solution to this privacy-induced problem. But I think what regulators are also trying to say is go and look at your own data transfers, map your own data flows, and think what other solutions there are to help the European exporter of data comply with local law in that scenario.
Indeed. I mean, we're talking about conversations as well on the politicians' front that are going to be handled behind closed doors, right? So a lot of this is going to be a surprise.
It's actually very important that European politicians and regulators keep a good flow of information coming out in the next few months so that businesses know where they stand and what's likely to happen. And that's certainly something that we'll be monitoring closely. But yes, it's a very interesting scenario with lots of different levels to it. The other aspect to it is that at the centre of the case was a complaint against Facebook, and now the Irish regulator will investigate Facebook, and the Irish regulator has said that they'll do that quickly, and that ruling may have some further information about the way that the law will be applied to this area. So that's another important item to keep an eye on. And then I think the other area to keep an eye on is just what are regulators saying? They've already, most of them, put out press statements, but there'll be a further drip of information. So we've got to take all of these strands together and really work out what is the best strategy for a particular organisation's data flows. There's not really a one-size-fits-all answer here. It'll depend on what the business involved does.
So tell me about some of the broader legal implications and some of the clauses you've had to incorporate to ensure that your clients who are worried about what the future might hold are able to still continue conducting business.
I mean, Europe's always been a fairly tough regulatory environment in this space. Where the law's going, and the sort of thing we're working with clients now to do, is to really show data governance measures within their organisations. It's all about showing that someone has ownership of this area, so appointing someone with European ownership of compliance is a really good step to take. The sorts of actions that person should then, or that team should then roll out: audits, compliance, privacy impact assessments, good data governance measures to show that an organisation knows how it uses European data and what it does with it. So it's very much a business needs to look busy in this area and needs to have assigned people and have assigned actions for their compliance programs.
Finally, leave me with one thought. We are talking about an economy continentally that needs as much foreign investment as it can get at this point. How is this clampdown going to impact the curb appeal of Europe?
I suppose if you're looking for a positive, it engenders an approach from suppliers and companies operating here with their staff as well, engenders a situation where people are respectful of data and their brand is enhanced and the value of the data that they have gained in Europe is enhanced.
So it's not a zero-sum game necessarily in terms of, hindering a company's ability to operate and to flourish.
I wouldn't look at it like that. I think it's part of brand building. And if you're operating in Europe, a part of a feature of that is that Europe takes data and data protection very seriously, and it's kind of culturally ingrained in a lot of people's customers and their staff. So if you're going to have people working for you over here and you're going to have customers over here, you kind of have to take that on board, and your brand will be enhanced. Or flip it the other way around, you're avoiding brand damage if you don't walk into a regulatory trap.